I think the appointment of judges for the higher judiciary in this country, albeit a very unique system, one of its kind in the world, is I think the best available system of all options that we have today. If you ask me, is that system fair? I think fairness is never absolute. It's looked at from the perspective of what the country, the society, and the demographics in that region needs.
So, for people who are not familiar, how does the collegium system really work like? And I would want to peg a criticism here that the word collegium does not find a mention in the Constitution. Some argue it's a judicial creation.
All that is not written in the Constitution of India expressly need not necessarily be bad, and all that is written in the Constitution expressly need not necessarily be good. And therefore, coming to how the collegium system works, I think we should demystify a little.
So, India is the only country where judges appoint judges. Is that a fair system?
The question should have been that India is the only country where judges appoint judges. So, isn't that a unique system? We should be proud of. If you ask me, is that system fair? I think fairness is never absolute. It's looked at from the perspective of what the country, the society, and the demographics in that region needs. And I think for all practical purposes, as we have seen it operate for the last so many years, I think the appointment of judges for the higher judiciary in this country, albeit a very unique system, one of its kind in the world, is I think the best available system of all options that we have today. Therefore, the answer is that yes, is that a unique system? Answer is yes. Is that fair? Yes, it is indeed fair, because you don't have a better alternative today.
So, for people who are not familiar, how does the collegium system really work like? And I would want to peg a criticism here that the word collegium does not find a mention in the Constitution. Some argue it's a judicial creation.
I'm tempted to answer it from another perspective. The word cabinet is not found in the Constitution of India. Yet we have a cabinet which is consisting of a bunch of ministers who take all crucial decisions for this country when it comes to governance, when it comes to policy, etc. Everybody in politics, runs around hula hoops to become a cabinet minister and not just a minister of state. So why is cabinet so important? Why is the cabinet taking so many decisions when the word cabinet is not found in the Constitution of India? We only find the Council of Ministers in the Constitution of India and not the cabinet. And therefore, all that is not written in the Constitution of India expressly need not necessarily be bad. And all that is written in the Constitution expressly need not necessarily be good. And therefore, coming to how the collegium system works, I think we should demystify a little in terms of what is this collegium system. Traditionally, and in any traditional democracy or constitutional governance, the executive has always had a great role in appointing judges to the judiciary. In some cases, the executive and the legislature have combinedly had a role in appointing judges. But in almost all democratic polities and mature nations, there is some sort of consultation that they do with the judiciary, no doubt, in appointing judges, particularly to the higher judiciary or to the constitutional courts. India stands out on it. Again, historically, India has had a system which operated for many, many years after independence, in which the executive had a far greater role in the appointment of judges as compared to the judiciary itself. And the first judge's case actually tilted the entire mechanism in favor of the executive. The result of the first judge's case or the SP Gupta case was that the executive will have a fair share, or maybe a greater than fair share. The executive possibly will have the last word in how judges are appointed. I'll give you some illustrations where very good judges have been appointed by the executive. Justice Krishna Iyer is one such name. Justice Khanna is one such name. There were phenomenal judges who adorned the benches of the Supreme Court, and they were all executive appointments, so to speak, prior to the collegium system. But that dark chapter of democracy, which led to the invocation of emergency, etc., led to a feeling that the executive had become overbearing in the manner in which judges are appointed, leading to what we call the second judge's case, which is the Supreme Court on Records Association. Now, the second judge's case ushered in a fresh chapter in the Indian constitutional democracy, because the concept of a collegium was evolved by this decision. It was then the Chief Justice and two senior most judges who will actually have the primacy in terms of initiating the process of appointing judges. They are the ones who will then consider candidates, make a recommendation, and that recommendation therefore had primacy in terms of how the executive will then take it forward. This was further polished in the third judge's case, which was the presidential reference to the Supreme Court. The third judge's case actually brought in the collegium system as we know it today, which is the Chief Justice of the Supreme Court and 4 senior most judges. When it comes to the High Court, the Chief Justice and 2 senior most judges, who will actually consider candidates, decide whether they are adequate, not adequate, appropriate, and then make a recommendation to the executive in terms of who should be appointed. Therefore, the primacy of that decision-making process was with the collegium and particularly with the Chief Justice of India. And the executive really had no role, or little role in terms of taking it forward, but no role in scuttling that process because the executive could not have said no to it or substituted another candidate. And then, of course, it would follow the process of going to the president and the appointment warrants being issued. At some point of time when the collegium started working, there was a multitude of criticisms. I think in any democracy, in any mature democracy where there is a plurality of thought, obviously criticisms come in. And I think some criticisms were fair, most criticisms were unfair as to how the collegium is working. And consequently, this whole scenario of saying, how can you be so unique that judges appoint judges? You are actually becoming autocratic from that perspective. There is an overbearing, dangerous dependence in terms of judges appointing judges and the power being centered in the judiciary itself. How can you not give an adequate role to other arms of government in a constitutional democracy, which is the parliament and the executive? All of that led to the scenario of the NJAC, being passed. A constitutional commission was created for appointment of judges to the higher judiciary. The 99th Amendment to the Constitution came in, and that was challenged. And that led to a further ushering of debate and thought process, and the NJAC was struck down by a 4:1 judgment. Spectacular dissent was by Justice Krishna, indicating on what ground. Whilst the dissent said that NJAC does not erode the basic structure of the Constitution in terms of judicial independence, it does not erode the primacy of the Chief Justice in terms of what the structure was, because the Law Minister, being a part of the Appointments Commission, was effectively 1/6, because out of the 6 members, the Law Minister was 1. So the executive having 1/6 of a share in the decision-making process is really not to invert the pyramid and take away primacy from the Chief Justice. Of course, there will be 2 other nominees part of the commission, but the nominees would be appointed by the leader of the opposition, the Prime Minister, and the Chief Justice, who form the decision-making process. So therefore, whilst the dissent opinion said that NJAC is fine, it's not unconstitutional, the majority simply struck it down on the basis that the NJAC, as it is structured, provides room at some point of time for the non-CJI decision-making process to override itself, which meant that the primacy which vested with the CJI hitherto, which was basic structure of the Constitution, because that was the epitome to ensure that there is judicial independence in terms of separation of powers, all of that gets eroded, and the NJAC, the amendment was struck down. So we therefore go back to the collegium structure. In gist, is the collegium structure functioning? As we see, it's functioning. Is it functioning well? That's a matter of opinion. I think it's functioning well. Some others might think it is not functioning well. But I always turned around and asked this question, saying that it's not about whether, from a subjective element, you say whether a particular process is functioning well or not well, whether it is appropriate, inappropriate. The answer that we should really find in a constitutional democratic polity is that if you believe that this structure is not working well, what other structure would work well? So you can't just find fault, you need to give the solution. We have not found a solution till date on having an alternate structure in our constitutional framework which will work as well as the collegium is working. Simply put, the executive predominance in appointment of judges didn't work well. We have had exceptional cases where fantastic judges have been appointed. We have had a great deal of the executive appointments not being so good, and therefore on a comparative analysis and in hindsight, I think the collegium structure is working absolutely fine until we find a better process in the future. It is always an appeal to the brooding intelligence of a future date that you will find a better structure tomorrow.